Well, good afternoon or good evening and welcome. I'd like to thank you for joining us for this virtual town hall. My name is Michael Gault, and I'm an eminent domain lawyer with Bell, Carrington, Price, and Gregg. Our practice group in the eminent domain section at Bell Carrington focuses primarily on representing landowners in cases that might involve eminent domain or condemnation. And if you're here with us for this particular town hall this evening, you know that we're here today to talk about the Murphy Highway Corridor Improvements and Safety Project. This project is one that started over 10 years ago with preliminary engineering dating back to 2014. But now we're in fiscal year 2025, and the information that we have shows that right-of-way acquisition is intended to kick off this year. What does that mean? Well, naturally, anytime you go to widen a currently existing corridor to create safety improvements along that corridor, as the footprint of the road grows, certain private properties might be needed in order to give the DOT the footprint to create that project. The government has the right through what we call eminent domain to take the property that they need to complete projects like this. Eminent domain essentially just refers to a government's right to take private property for a public purpose. This project, we like to judge the size and the potential impacts of these projects by their budgets. This particular project is broken down into two project numbers, but when you combine the right-of-way budget for both of those project numbers, you come to nearly $17 million of right-of-way budget. That to us indicates a significant impact to a number of properties up and down the Murphy Highway corridor. If you received a mailer from us, it's probably not the first time, but this particular town hall is guided and directed toward those of you who our information indicates likely have an impact in some way to your property. Sometimes those are residential, commercial, or industrial impacts, depending on the nature and the use of your property, but your rights as a landowner are ultimately the same. When we have these town halls, I personally like to focus on three major points. The first is you as a landowner have rights, and I'll go briefly into what those are. The second involves our initial consultation structure, and the third involves our fee structure. So rights as a landowner, what are they? We rarely, if ever, focus on trying to stop a project from coming through or changing plans on a large scale. That's generally just not possible. The law is pretty clear that state governments and departments of transportation have the right through eminent domain to take the property that they need to complete projects like this. And so we focus on the one right that you as a landowner do have some control over, and that's the right to just compensation. Put simply, that just means that even though the government can take some property from you, they have to compensate you fairly and adequately for what they're taking. Unfortunately, that computation is not easy. It's not mathematical. It's not A plus B equals C. Sometimes the damages to a property may be hidden. They may not be as clear to a governmental agency as they are to you as a landowner. You may have some future plans that you can't complete because of the impact to your property. You may lose some landscaping, or maybe if you have a residential property, a septic tank might be impacted. There are any number of potential impacts to your property, regardless of the use, that you likely may not be offered up front during your initial offer process to be compensated for. And that's where we come in. We have a team of lawyers and staff that work on projects like this and impacts like this day in and day out. And so we're well versed in the procedure, oftentimes the players involved, and certainly well versed in finding and then advocating for those damages that the department may miss during their initial offer process. That's step one. You have a right. Your most important right is the just compensation. I would encourage you not to sign anything quickly with anybody that makes the initial contact with you, but to instead set an initial consultation, which is point number two. I can certainly sit here and give general information about the project and about eminent domain and the process, but I can do a much better job of diving down into your particular impact, talking about what details I see in the plan sheets on your property and how we might be able to help you through a one-on-one consultation, through Zoom, through Teams, through just a standard phone call. Happy to have myself or a member of our team to hop on there with you to schedule those initial consultations, to in real time use our software to look at the impact to your property, to see what things stick out to us, and how we might be able to analyze those and then advocate for you in making sure that you're compensated for those impacts. Again, those impacts can range greatly from a residential strip take, which is just a small portion of the frontage of your yard, to commercial impacts, in fact, impacting access, maybe changing from full access to left in, left out only, or maybe light industrial impacts that impact the way that vehicular traffic, particularly truck traffic, can circumnavigate within the existing parcel lines. And finally, oftentimes landowners are concerned about exorbitant attorney's fees, outrageous attorney's fees. Are you going to have to pay more to a lawyer than you could have gotten from the department on your own? That's my third point in these town halls, is that we have a unique fee structure at Bell Carrington in our eminent domain practice. It is a contingency fee structure, and it's based on the increase in just compensation that we're able to get for you over and above the initial offer. We would never ask for any money out of pocket from you. We don't ask for anything up front. There's no retainer fee, and we don't bill you hourly. And so in that regard, our interests are certainly aligned. We're focused on identifying those impacts, maximizing the just compensation received by the landowner, and ultimately the landowner is not on the hook for any attorney's fee until the case is either settled or a verdict reached at trial. So to recap, you have rights. Just compensation is the most important. We want you to be compensated fairly and adequately for what you're losing, and we want to be able to help you to identify what you're actually losing and then advocate for you on your behalf. Number two, those initial consultations are always free, always no obligation, and that's the best way for us to connect with you about the impact to your property on a deeper level with more detail, one-on-one during that consultation. And number three, no out-of-pocket money, no upfront retainer. We charge a contingency fee based on the ultimate amount received above and beyond the initial offer. So let me finish the town hall here. I will add my name, Michael Gault. I'm the practice group manager with our eminent domain team at Bell Carrington. I'm going to enter my direct email and line. I want you to be able to skip any sort of receptionist or roadblocks. Get right to me. I'll be glad to schedule a time to speak with you. You can also visit our website at bellcarringtoneminentdomain.com. There are a number of ways through that site to schedule a consultation with a member of our team, or you can fill one of our fillable forms that will give us the information needed to reach out to you directly. Whatever's best, a number of convenient ways there. Again, Michael Gault on behalf of Bell Carrington, and I look forward to speaking and hopefully working with some of you in the future. Thank you. Have a good evening.